Greetings once again from my basement, where your question, I wonder what the Youngstown steel plant looks like now, is answered. And, well, actually, perhaps not answered. That may be fake news, because I don't know if that's anything like a current picture of what it looks like. But at one point, after it had fallen into a bit of disrepair, it looked like that. Perhaps it looks more like a vacant expanse now. We are here. Well, I'm here. You're not. You're there. We're gathered together here in this internet realm to discuss one of the more significant cases of the semester, a case with quite a bit of relevance given our current situation, since it involves presidential power in situations of emergency. So I've got some good new slides, I think, for this one, and hopefully it ends up being a good sort of discussion. Here's our Kickstarter. We've seen it. We talked about it in the last video I put together. I'm not going to linger on it here right now. We will return to it at the end and walk through how it applies to the Youngstown situation. But I kind of want to talk about the other stuff first, and use that as kind of a capstone of sorts for this discussion. So some things to talk about just to set the table here with respect to executive power. And probably the first thing we ought to think about is what do we mean when we talk about executive power? Touched on that a little bit in the context of the general separation of powers discussion. This is just a slightly more refined version of that discussion. So, of course, the root word here is execute, not in the sense of killing, although that certainly works, but in the sense of executing a plan. Right? That's what the executive does. The Congress is the supplier of the plan. The president is the one who executes it. From Black's Law Dictionary, it's defined in the following way. The executive is distinguished from the legislative departments of government in that it is the one which is charged with the detail of carrying the laws into effect and securing their due observance. So, in an abstract, general sense, that's what the executive power means. Of course, where exactly the edges of that power lie and how they relate to the judicial and legislative powers are the topic of our discussion here. It's worth opening as well with a little bit of compare and contrast here between sections 1 of both Article 1 and 2 of the Constitution. And the key here is or the key point I want to leave with you is this notion that in Article 1, the vesting clause includes this herein granted language. Right, so the clear suggestion there, which is consistent with our approach to the topic over the past several weeks, is that Congress's power is limited to those that are expressly granted to it, right? It's that exercise we perform of we got to pull out the Constitution and ask, and when the question is, does Congress have the power to do this? Is there something in the Constitution that gives it the power to do this? Now, practically speaking, we know that limitation may not be all that significant because the commerce power is pretty extensive, but there are limits, as we have seen. Now, take a look at the first sentence of Article 2, the vesting clause there. There's no herein granted there. And one of the questions that comes up then is what's the significance of that? Does that mean that the president's power is not limited to those things that are expressly granted? In other words, are there things that are inherent, powers that are inherent in the notion of being an executive that the president has, even though they are nowhere specified in the Constitution? And that's one of the big topics In Youngstown, one of the big topics with respect to executive power generally, and in particular when it comes to emergency sorts of situations. And, if you look at, and I know there's a lot of text on this, but the red sections are meant to sort of highlight the powers that are expressly granted to the president. There's a good number of things there, but it certainly doesn't cover the waterfront in terms of things that we might expect to see the president or an executive engaged in. So there is a debate. There's a long-standing debate that goes all the way back to Alexander Hamilton about the significance of that. And Hamilton said, what this means is that the framers did intend to vest the president with inherent powers, with powers that are not expressly articulated in Article 2 of the Constitution. The contrary position, and Hamilton's got a worthy foe here in the form of James Madison. Madison's position is no, what this language was meant to do is simply to establish that the executive authority would be vested in a single person as opposed to distributed amongst multiple people, the way it is, for example, in some states, and to give that person a title, right? So it's one person, that person's called the president. Madison's view is that's what this does, and doesn't imply anything about the existence of inherent powers, and perhaps he'd even suggest the notion of inherent authority is flatly inconsistent with the idea of a constitution creating a government of limited powers. That's a long-standing debate. It is not one that has been definitively resolved. I think part of how one answers the question, are there inherent presidential powers, depends a little bit in part on how you define the notion of inherent and how tightly one wants to be constrained to the actual grants of power here in sections 2 and section 3. Another note worth making is one thing that seems undeniable as a description of reality is that there is a built-in sort of pressure towards the accumulation or accretion of power in the executive branch. And it's almost sort of baked into the system because Congress faces all sorts of coordination problems in acting, in responding to situations. We're kind of seeing that play out right now where Congress is haggling over a stimulus package addressing the current crisis. It's difficult, right? It's difficult to resolve those sorts of agreements because there are so many moving pieces and so many interests involved. It's a whole lot easier for a president simply to act, simply to do something. And when the president does something in response to an emergency, unless things go very, very badly, it's unlikely to be the case that Congress is going to say, well, no, we're going to undo that. And so there's kind of a one-way ratcheting function that often comes into play that leads to the president gradually accumulating powers over time. So that is a thing that has happened. That's a critique that's lodged against the modern presidency. It's been lodged by both sides, as they say, and it's just the group that doesn't have the presidency that's lodging the complaints most loudly at any given time, it seems, lately. It certainly does seem to be the case, turning now more specifically to emergency powers, that the president absolutely has some ability to react in the face of an emergency. And, we can imagine that both in terms of, say, tying it to the text and something like the commander-in-chief power, right? Imagine the president has some good intelligence suggesting that there's some sort of attack that's imminent. No doubt as commander-in-chief, the president could draw on that authority to preemptively react to some sort of strike, even in the absence of any kind of congressional authorization. We could work through some of the rest of these. It's a little bit harder to make that sort of argument with respect to granting reprieves and pardons. I mean, that's a power that's clearly clearly exercised at any given point. You don't preemptively do that; you just do it. But the commander-in-chief power, maybe the take care that the laws be faithfully executed power, those are things that perhaps the president is going to be able to draw on sometimes to act preemptively or quickly in the face of emergency situations. But there's a real question about just how far that extends, and that's kind of what's at stake in Youngstown. So here's the background in this situation. So the Korean War is in progress, and ammunition supplies are running low. The U.S. has international commitments to supply weapons and ammunition to its allies. And we've got this situation where the Steelworkers Union is threatening pretty seriously to go on strike. And so President Truman reacts to this by announcing a seizure of the steel industry. And, worth noting that at the time the Taft-Hartley Act exists and would have allowed President Truman to postpone any strike for 80 days. So there was a statutorily authorized mechanism available to the president to attempt to deal with the consequences of a strike. But Truman didn't think that was good enough. So Truman seizes the steel industry. 10 days after this takes place, there is a question asked of the president that really gets to the heart of just how broad do these inherent powers that you think that you have extend. And Truman answers in a way that is basically says, I got the ability to do what I think is best for the country. That's an awfully broad power, but certainly, I think presidents feel the temptation to act in that sort of way. But that is not a statement of the black letter law. Of that much, at least, we can be certain. So this all goes down in April. The Supreme Court grants expedited review. Here's argument in the case in mid to early May, and it issues its decision really quickly, June 2nd. That's very, very fast track decision making for the Supreme Court. There's some criticism, at least historically, of the court for its intervention here. The evidence suggests that the parties were close to reaching an agreement, the union and the steel mills, but then they got word that the Supreme Court was going to hand down its decision, and that broke down. It may or may not have been a good idea for the court to get involved here, but it did, and we got a very interesting case and a very interesting set of opinions out of the deal. I want to talk a little bit about Black's majority opinion, but as Kaplan suggests, the real influential opinion here is the one authored by Justice Jackson. And so that's the one we're going to spend the most time on, because even though it's not a majority opinion, it is the one that has subsequently carried the most weight. Simply, we'll talk a little bit about why that might be when we get to it. But Justice Black's opinion for the court basically takes the position that there's no inherent power, that the president's power here can come from one of two places. It can come from an act of Congress, right? So if Congress exercising some valid power that it has passes a law authorizing the president to do something, then no doubt the president will be authorized to do that thing. Here, there is no law passed by Congress that authorizes the president to seize the steel mills, and in fact, the evidence suggests that Congress considered giving the president that power, but decided not to, which suggests not only did Congress not give the president the power, it didn't want the president to have the power. So the other place that the power could come from is the Constitution itself. Is there anything, when we look at these provisions, is there anything in here that says the president has the power to do something like this? And the president's lawyer offered up two primary sorts of justifications for this action here. And so there are three textual components to it. One of them starts here with the vesting clause itself, right? The executive power shall be vested in the president. That's one piece of textual authority that Truman is relying on. The second is the notion that the president is commander-in-chief of the Army and Navy, and because this is connected to a wartime effort, the argument runs the president's commander-in-chief power entitles him to do things like this in order to be able to effectively prosecute the war that the country is currently engaged in. So that's piece two of the textual argument that the president is making, and that maybe is the strongest piece. And then there's the reliance on the take care clause here, right? That the president shall take care that the laws be faithfully executed. And here again would be the idea would be that the Korean War effort is appropriately authorized, and so in order for the president to take care that endeavor be faithfully executed, he's got to take a step like this. Coupled with those textual arguments is an argument that the president has these inherent powers. Again, the idea there is that there are powers that just are part of, they're just built into the notion of being the executive, and they exist even though they're not listed anywhere here in the document. And maybe the textual stand-in for them is just this. It's the executive power. And executive power, by implication, includes all this other stuff. And so the president's saying, I got inherent powers, and supports that argument by resorting to historical precedent, right? Says, look, I can point to instances in the past where my predecessors engaged in seizures of this sort during national emergencies. I can point to all sorts of stuff that President Lincoln did, including the Emancipation Proclamation, as things that were unilaterally undertaken by presidents in the absence of express authorization by statute or by the Constitution, which signifies that those presidents must have been drawing on inherent powers. And so if they had them, I've got them too. Those are the arguments that Truman makes. Justice Black's opinion rejects all of them. Not there. There's no act of Congress. The commander-in-chief power does not extend so far as this sort of situation. And the take care clause, whatever it gives the president, does not give the president the authority to engage in lawmaking. And Justice Black's opinion clearly suggests that this is lawmaking. And that is most clearly evident, I think, in the second full paragraph on page 564. That first sentence, the president's order does not direct that a congressional policy be executed in a manner prescribed by Congress. it directs that a presidential policy be executed in a manner prescribed by the president. And the rest of that paragraph goes on to talk about ways in which this looks legislative. And Justice Douglas's concurring opinion also develops even further the idea that this is legislative power that's being exercised. He ties it to the takings clause. Okay, so that's Black's opinion for the court, but again, it's not the influential opinion. The influential opinion here is Justice Jackson's concurrence, and I got to tell you, this is an opinion that, for me, every year when I reread it, it reveals new things to me. It truly is one of the most wisdom-filled opinions in this course, and I was reflecting on that a little bit this afternoon as I was reading through it and being struck by it once again. It's the sort of thing, and I think that the first 3 paragraphs or so in particular, but not only those, are the sorts of things that I think are easy to sort of read as, throat clearing or platitudes, obvious statements the first time or 2 or 3 through them. And for whatever reason, and I guess I'll suggest to you that as you make your way through life, you accumulate perspective and hopefully wisdom. At least the ability to appreciate wisdom when you see it in other people, and maybe the ability to sort of imagine a little bit more what the world looked like through Justice Jackson's eyes at the time he wrote it, in a way that I don't think I could do at every point in my life. So it may not resonate with you as much as it resonates with me, but there's a lot of good stuff there. This paragraph that I've got on the screen right now, I think it's a point that, I guess it's obvious, but it's also a trap that people consistently fall into, no matter how obvious a trap it might be. It's easy to find ourselves persuaded by arguments that support a result that we like, because we like the result, and to lose sight on enduring consequences. One of the things that legal reasoning, legal training, hopefully leaves us with is an ability to sort of engage in second and third level reasoning beyond a particular situation, reasoning that considers the question, if I do X in this case, and if I am to be bound by principle and reason, what are the implications of my decision in this situation, my invocation of principle in this situation for later different situations that I'll have to confront. And that's simply what Jackson's emphasizing here, right? He gets it. He's served in presidential administrations. He understands the temptation to act in a unilateral way, act in an efficient and expeditious way in order to achieve what appears to be a good result in a particular situation. He understands that. Now he's a justice on the Supreme Court, and he understands that his role is to remove himself, abstract himself from that to the extent that he can, and that's a valuable thing. So I really like those opening paragraphs. I suggest give them a couple reads. Maybe they'll strike you as well. He goes after those. He says basically, look, we can think about situations where we're looking at presidential power and divide them into 3 rough categories. The first of which is a situation where Congress has said it's okay. Either expressly, that'd be the best, or impliedly, it has said, President, we're on board with what you're doing. And that's a situation where it is most likely to be the case that the president's power will in fact be a valid and validly exercised power, because there the question is, does the United States government have the authority to do it? And only if the United States government does not, will the president not be able to do it. And I suppose we could qualify that a little bit, where if Congress purported to give the judicial power to the president, that would be a problem as well. But basically, if Congress says it's okay, pretty good chance it's going to be okay. That's not this situation. Congress has not said it's okay for the president to do this. The second situation is one where Congress hasn't said anything. Congress, has simply been silent, or Congress doesn't have the authority to speak to a particular situation, or Congress does have the authority to speak to a particular situation and it hasn't. Maybe it's acquiesced. Here, there's a lot of it depends going on. Here's where we get into that twilight zone that he mentions. Really hard to say much general about those sorts of situations. But there'll be a pretty good chance that the president will have power there, just depending. But that's not this case either. This case is in the hardest category, or the least likely for the president to have authority category, which is ones where Congress has said, no, you can't do that, or at least it has said, if you're going to do that, you have to do it this way and not that way. And in that sort of situation, the president might be able to act, but the president has to be able to point to something in the Constitution that says, this is my job, this is a situation where I've got the authority to act, even if Congress has attempted to tell me that I can't. In other words, Congress can try to tell me no, but I don't have to listen to it because the Constitution says I don't have to. That is this sort of situation. And so Jackson says it's possible that the president has the power here, but only if we conclude that this is a situation where the Constitution gives that power to the president, regardless of what Congress says. So he walks through a bit each of the components of the argument that the president's lawyers have made, starting out with this general proposition, really, which amounts to his conclusion that the president doesn't have inherent powers. The president has delegated powers. And so in Jackson's view, we got to look to Article 2. We got to look to that list of power. We're not going to construe it narrowly. So we're going to be a little bit like Chief Justice Marshall in McCulloch versus Maryland. We're going to remember that it's a constitution we're expounding. And so we'll draw some inferences and give the president a long leash, so long as it's tethered to one of those powers. But he's not going to find inherent powers. All right, so what are the delegated powers that the president's leash here might be tethered to? Well, looking back at the ones that the president's lawyers invoked, as we've discussed, there's the vesting clause. Executive power shall be vested in the president. Jackson says, I look at that and I don't read that as some blanket grant of power. I'm not with Alexander Hamilton in my interpretation of what the vesting clause does. I don't think it's a blank check. I also don't think the commander-in-chief power does it here. It's got to be limited to not the Army and Navy. The president's commander-in-chief of the Army and Navy, not, quote, of the country, its industries, and its inhabitants. And so this is a situation that is too far outside of the context of the exercise of military authority, he's not willing to expand that power to this sort of situation, nor does he find it anything compelling in the take care clause. He says basically, in fact, that kind of pushes me in the other direction, right? We look at the take care clause together with the due process clause, and to me, that signifies about all there is of the principle that ours is a government of laws, not of men, and that we submit ourselves to rulers only if under rules, which is, of course, kind of exactly the opposite of what Truman is seeking here. Jackson then goes on to think about or to consider the prospect of inherent powers, and says, I don't see it. The framers of the Constitution certainly foresaw the possibility of situations like this. They knew what emergencies were, and they didn't include any clause in the Constitution giving the president any sort of general power to respond to emergency situations. Why? Well, they knew the pressures that emergencies engender for authoritarian action, that they provide a pretext for usurpation of power, and we may also suspect that they suspected that emergency powers would tend to kindle emergencies, right? And I kind of think about that along the lines of the roof at Miller Park. My understanding when that ballpark was built was that the operating line was, we're only going to use that in the more extreme sort of situations, where it's actually raining, where it's actually cold. It's for emergencies only. Well, as somebody who's had ticket packages to Miller Park for well over a dozen years at this point, I can tell you that the notion of an emergency there has been expanded to mild forms of discomfort. That roof is closed much more often than the early indications would have suggested, and much more often than someone like me would prefer. So that's that kind of dynamic. And then Jackson looks around and says, things, we had a little bit of a bad experience with Germany and its exercise of emergency powers, and so that suggests as well that probably we don't want executives with too much in the way of emergency powers because bad things tend to happen. So that's where Jackson ends up. Why is his opinion so influential? Well, part of it is because he's an extraordinarily good writer. A lot of his opinions are influential in that way. I think it probably helps a little bit in this context that given that this case was decided so quickly, every single justice authored an opinion, right? Nobody really fully signed on to Justice Black's opinion for the majority, and so, it is formally designated as a majority opinion, but really hasn't been treated in that sort of way. Briefly, just talking about some of the stuff in the other opinions, Justice Clark's opinion says, sometimes extreme actions are necessary. Sometimes you got to act unlawfully to preserve the law. Lincoln, for example, did some stuff that wasn't technically authorized, but that he rightly thought was indispensable to the preservation of the Constitution through the preservation of the nation. That sort of thing is going to be okay. We might, one situation like that we have perhaps encountered, that we did encounter. If you think back to the very beginning when we were considering the fact that the framers of the Constitution didn't follow the procedures in the Articles of Confederation, right? They're acting unconstitutionally according to the standards of the time because they thought it was necessary to preserve the nation. So That's an argument that, sometimes is going to seem okay, right? We think that's a good idea. When Lincoln does it, we think it's probably a pretty good idea when the framers of the U.S. Constitution do it. We don't think it's a good idea at all when Hitler does it. We probably don't think it's such a super great idea when Vladimir Putin, does similar sorts of things. So beauty in terms of that sort of thing is very much in the eye of the beholder, and you better hope you got the right leader when relying on that sort of executive power. Chief Justice Vinson, going out of order here, looking down to the dissent, he's willing to point to plenty of historical precedent for the exercise of these sorts of emergency powers by presidents as well. Obviously, the justices in the majority are unpersuaded by that, basically willing to say, and I think this is expressed in at least Justice Black's opinion, willing to say that, look, yeah, it may have been done in the past, but that doesn't mean that it was right when it happened in the past, and we're not going to sign off onto it here. We could also harken back a little bit to Justice Jackson's opinion in Korematsu, right, where he says, it's one thing for us to sign off on something like that, which the court didn't do with respect to these earlier historical examples. One thing to just let it happen. And maybe some of the wisdom of his opinion in Korematsu kind of comes through here, right? If we take it to be the case that the Supreme Court never got involved in any of those past instances of presidential seizures, never ratified them, that then frees it when it's presented with a situation like this to say, no, we're actually going to follow the rules here. As I mentioned earlier, Justice Douglas makes kind of the most express case for why this is legislative, because it is a taking, which is something that is clearly designated as part of Congress's responsibility, and therefore that counters the suggestion that this is something that the Constitution vests with the president, certainly with the president exclusively. So just to think about this in terms of the Kickstarter and kind of integrating some of the opinions together a little bit, does the Constitution's text speak to this? Well, I think it's fair to say that Justices Black and Douglas at least are of the view that the text resolves the case. That is, I think it's fair to say, not enough for the concurring justices, and it is likewise not enough for the dissent. But you got two justices who would agree with the conclusion, or seem to agree with the conclusion, that the text is all they need in order to resolve this. B1 is a branch seeking to act outside its usual areas of responsibility. Here there's a lot that's in the eye of the beholder. What is the president's usual scope of activity? What is the nature of the conduct here? Is this truly legislative conduct that the president has engaged in, the way Justices Black and Douglas regard it as being? Or is this instead something that looks more like commander-in-chief type activity, the procuring of war supplies, the insurance that war supplies are properly manufactured? Characterized in that way, there's a seemingly stronger argument that this is a branch acting within the scope of its usual area of responsibility, right? So understand here that there is an art not only to how we make the legal arguments, but also there's a sort of a factual dimension to it as well. How do we characterize the nature of what it is that, in this case, the president is actually doing? How should we think about it? What boxes do we fit it in, and how can we mold the facts or characterize the facts in different ways to make them fit in different doctrinal categories. Will the challenged action interfere with the ability of another branch? Here, if you're the president, here's a point we haven't talked about, but President Truman said, look, I'm willing to follow Congress's instructions on this. If Congress tells me it doesn't want me to do this, I'll respect that. And so he'd say, I'm not interfering with Congress's ability to act in its usual area of responsibility. Now, on the other hand, he does act in a manner that is clearly contrary to the previously existing instructions that Congress has given. Namely, if you want to deal with a situation like this, you resort to the Taft-Hartley Act and you suspend the strike for 80 days. You don't get to seize the steel industry. And so, here again, there's ability for characterization to take place. It's also a situation where part of the analysis would take into account, who's the first mover here. And here the first mover is ultimately Congress, because Congress has anticipated a situation like this and provided a mechanism for dealing with it. And so given that, it seems more compelling to say this is interfering with Congress acting in its usual area of responsibility, as contrasted with the situation where the president was the first mover, right? So imagine instead of what actually happened, we're in Jackson's Category 2, where Congress hasn't clearly legislated here, hasn't prescribed a framework for dealing with this sort of situation. The president seizes the steel mills. Now, the argument that the president has interfered with Congress's ability to carry out its responsibility is at least a little bit less compelling, because Congress hasn't prescribed anything in advance. It's a sort of a subtle point, but sometimes it's the sort of thing that matters. Institutional competence. If you're the president, you're going to say, look, I'm the one who knows what the military's needs are. I am the one who is best positioned to satisfy those requirements and to make judgments about what's necessary to do that. Congress would say, there's another dimension to this, and maybe this is, and here's another point we haven't really talked about. Maybe this is as much about labor policy as it is about military need, right? Maybe this is as much about the president wanting to satisfy his labor union constituency by seizing the steel mills, entering into a labor contract with them while the government is in control of the steel mills, and only then giving them back. And if it's really about labor policy, then that's something that Congress ought to be involved in. That's something that Congress probably has better competence to deal with. So those are how some of the arguments would shake out there. What about some of the other methods? Well, we've talked about text, we've talked about structure. Precedent, there don't really seem to be any past court decisions that relate too closely to this. The precedent here is more of the historical variety of the sort that the dissent in particular relies on. Justice Clark invokes as well. Consequences and values seem to be doing work here. Obviously, a president that has too much power and too much discretion is something that the justices in the majority regard as a bad consequence. Conversely, it would be fair to suggest that the dissent says we fear weak government. We fear potential loss of the war as a result of this. Those would be bad consequences. So here too, it's possible to make arguments in both directions. In terms of values, obviously one value is the rule of law, limitations on executive power, adherence to normal channels of lawmaking. Those are all values that that the majority exhibits, and the dissent, tends to emphasize the value of things like national defense in counter to those. So lots of arguments in both directions in a case like this. So and I think it's a really good illustration of separation of powers analysis generally, and really how many moving pieces and how complicated these things get. A final thought on inherent power. I mean, one thing that is clear is that presidents have absolutely, throughout history, exercised powers that are not expressly provided for in the Constitution. So, for example, the president has an established power to recognize foreign governments. The president has the power to remove presidential appointees. And briefly, with respect to that latter one, if we go all the way back, we see that the president has the power to appoint, and here's various people who the president has the power to appoint: public ministers and consuls, ambassadors, judges of the Supreme Court, officers of the United States. So things, and the boundaries of who's an officer of the United States are not so clear, but things like members of the cabinet, right? The various secretaries of state, treasury, and so forth. And what Article 2 gives to the president is the power to appoint them, and it requires that the Senate provide its advice and consent with respect to those appointments. Well, a question that comes up is, what if I'm the president and I want to remove some of those folks from office? Do I have to go to the Senate to get its approval for that, or can I just do that? And the answer has turned out to be that the president basically can just do that. It's a little more complicated than that. That's another reason to take administrative law. But it's not expressly provided for in the Constitution. So maybe it inheres in the appointment power. Maybe this is simply the product of the sort of loose construction that Justice Jackson advocates. But in any event, if inherent powers are taken to mean powers not expressly given in the Constitution, then the president has them. If they are meant to mean something different than that, something beyond the long leash that Justice Jackson would give them, then there's an argument that they do not exist. And with that, I will wrap this up. I know this has been a bit of a long one, but there's a lot of good and important stuff here. So we'll end it, and I will see you in the next one.